The law matters, and that's why we're here, to help you. Welcome to The Law Matters. I'm Deb Moraes, your host and moderator. As we tell you, this program is dedicated to making legal information more understandable and accessible to you, because when it comes to the law, knowledge is power. We're working towards that. Each episode that we present is designed to offer clear insights, relatable examples, and practical advice designed to help you navigate the complexities of law and the legal landscape, and so that you'll do it with more confidence. Whether you're designed or planning to handle the matter yourself, or whether you're preparing to work with an attorney, our goal is to equip you with basic foundational information so that you can make informed decisions. From protecting yourself and your family to your own business matters, we're here to help you, as we always say, save time and money, and our aim, of course, is to have you achieve the best possible outcomes. And as always, we want to welcome and thank Attorney David Bazar from the Bazar & Associates law firm in East Providence, who continues to offer his expertise on the various issues that we tackle. So today, sort of as a follow-up to our discussions about estate planning and those difficult issues, we're going to be talking about estate settlement, the legal and financial process that goes on in handling a deceased person's affairs. Understanding that process, I think, as we've discussed, helps you really wrap your mind around what needs to happen, because it certainly can be complicated and time-consuming. So we hope you'll stay tuned in this session so that you'll know a little bit more about everything you need to know. What's a RESPA? What's an EIN number? What do you need to know? Do you always need a lawyer? In all cases, there are some basic steps. I understand there are 9, and I'm not going to put you on the spot to just do that way, but let's go through and break down what happens in an estate. The last time we were speaking, it was how someone plans about their property and their assets. So once someone's passed, what happens?
So if you've done the plan and everything's in place.
Estate plan or a will, excuse me.
Estate plan, for me, means it can be a trust, it can be a will-centered plan, it can be a trust-centered plan. It's just having a plan.
A plan, okay.
Some document in place that says what's going to happen. And, it's interesting because sometimes people think that, well, and especially if it's a husband and wife, my spouse died, I don't have to do anything. And you do. And I recently had a client come in who wanted to make a minor change to his healthcare power of attorney. And he wanted to add in that if he died, he wanted to be cremated and have his ashes with his wife's ashes. So I went through it with him and I said, well, what about anything else? And I was telling him, by the way, your wife is your primary agent, and then one of your children, your secondary agent. And he said, oh, well, my wife died. And I said, oh, I'm sorry to hear that. But obviously we have to change the first agent to whoever you want and that, but you have other things you have to do. And I know he was thinking, well, the house was in joint names, the bank accounts were in joint names, and really, why do I have to do anything? But they owned real estate. And in Rhode Island, if you die owning real estate, even if it's joint with somebody else, there's an automatic inheritance tax lien. And you have to have that discharged. And the way you have it discharged is you have to file an estate tax return. And even if there won't be, if everything's left to the spouse, even if you're over the threshold, there won't be any estate tax due, but you still have to file the return to get the release filed. And also, of course, he was thinking about just adding that one little phrase for his cremation and his ashes, but he needed to update all of his documents to account for the fact that his wife died and to make sure he had everything else in place.
What other documents? Insurance policy, I don't know.
Yeah, so that was just the initial thing with him. That was the estate settlement part is actually pretty easy because all the accounts are now in his name. But In a more complicated situation, there's a number of things. So here's the situation as it usually happens. Somebody calls and will say, my mom died, or my husband died, or whoever it is. And we'll have them make an appointment and come in. And we'll tell them they need to bring 3 things with them initially. We send them a form, which is all of the financial information that we want, because we need to understand what all the assets are that were owned by the person who died, even if they're joint. We need a death certificate, and we'll also need the names and addresses of all the beneficiaries. And so we'll start with those basic things. And so when someone comes in, we'll start going through the assets to determine what has to be done. So, for example, as you said, there could be life insurance. So we'll want a copy of the life insurance policy if you have it, or information about the life insurance so we can get the claim form for that. There'll be the real estate, and so want a copy of the deed and all of that. There'll be the bank accounts. Usually a retirement account. We'll want to know where the retirement account is and be able to get a beneficiary claim form for that. And all in all, whatever the assets are, we need to do that. And so what we do when we get all the assets is we create a spreadsheet so that we know, all right, here are all the assets. So this is what's part of the taxable estate. Here are the assets that might have been in the person's name alone, which would be the probate estate. And so we'll begin with that.
When someone has those documents, it might take them a week or so to get those together. Is there a time frame? Sometimes things could be very simple, but sometimes they might be complicated. I know we were talking about, suppose you had property in another country. I can just imagine that that's difficult. And don't you need more than one copy of the death certificate? Usually others are going to want all of that. Does that go on and on endlessly?
In the old days, we wanted 3 or 4 copies.
Yes.
Today, it's interesting. A number of the things that we need to do are done online, by email and that type of thing.
Okay.
And so
scan it?
You scan it, download it, and send it, usually. Certain things are still requiring an original. You know, if you're probating the estate, for example, you need the original death certificate for probate. But life insurance, a lot of that can be claimed through online or scanned documents, so you're scanning it in and sending it anyway. So we don't need as many as we used to.
Good to know. I had been involved with one where the person's Facebook page needed to be taken down, and even with that, it required that you send a copy of the certificate of death to do it.
Actually, a few years ago, I had a much more difficult situation with that, where they wanted the will to be probated and an executor appointed to have the authority to take it down. They
Really?
weren't satisfied at that point in time with just the death certificate. And there were no other assets to be probated. So it was, you're basically making us file a probate for no reason. We added in to our powers of attorney the power to maintain or deal with digital assets. And the power of attorney says that it usually dies at death, except for a period of time to deal with certain things, which was put in primarily for dealing with digital assets.
And I guess this is probably a good time to bring it up again while we're not specifically speaking of someone's assets. If you are doing these things on your own, and as we know there, and have told our viewers, there are some things that you can do online, but it really is important for them to somehow have some documentation about the access to all of their online accounts, even if they needed to have subscriptions canceled or things changed. And I'm sure when you're dealing with estates, that's part of their assets, whatever their digital assets are. And I can't even imagine Bitcoin. That's another whole story.
Well, I say digital assets and people think Bitcoin right away, but I'm also talking Facebook, Instagram,
exactly,
all of that.
All of those things, and they need to be. Oh, Social Security. All of those things, are they done online now, or do you have to do them?
All right, so here's what happens. If you die, generally there's going to be a funeral home involved. They notify Social Security. And then Social Security notifies the bank. So the bank usually, that the deposit goes into, finds out pretty quickly.
And it goes back.
And then after it's gone in, depending on the timing, it then goes back. They claw it back, so to speak.
They claw it back. Well put. Do you also, when you're doing your spreadsheets, do you also have to record who the contact is for each of these places and who's taking care of it and they're next in line? I mean, it seems like that could be a multi-page spreadsheet before
the
long.
assets go on the spreadsheet. Then we have another form that we use as a checklist, because the paralegal is going to contact every agency, company, whatever it is, to claim all the assets, to make sure that they all get into the estate or the trust and then are distributed out as they're supposed to be distributed.
We talked last session too about there's value obviously in having an estate, and sometimes a lawyer could be the person who's going to be taking care of giving Johnny his disbursements. So you'd be get paid a fee to do an estate plan. Would you also be paid as an executor? Does an executor get paid? How does that happen?
An executor can be paid. Oftentimes an executor is a family member and they don't want to be paid. You know, some do. And we'll tell them that if they do want to get paid, they should keep track of their time, and they can only charge a reasonable fee for what they're doing.
Do you let them know what a reasonable fee is?
Well, I know what a probate court might find reasonable, and it could be anywhere from $25 to $50. And if it's a complicated work that needs to be done, they might get $75, but usually $25 to $50, and $50 being the middle range.
Well, I was going to say, one of the things I know they say always is acquire all the documents, take inventory of your assets, and if you have properties and things that need to then be dispersed, is it part of an estate that you have to have that appraised, or is that, and if you aren't doing it, someone who is doing it on their own is going to have that settled somehow? How does that play out, David?
We only got to the first appointment. We haven't gone to what we do next.
Okay.
All right. So the first appointment was bring in all of these things.
Bring the documents.
We create the spreadsheet. We have you come back. We'll figure out what a fair fee is. And I like to do it rather than hourly on a flat fee, so you know what it's going to cost and what's going to be covered. And we create a retainer agreement that lays all of that out. And then we start doing the work. So here's what the work is. We have to gather up all the assets. We have to file an estate tax return. And the estate tax return, depending on the value of the estate, will either be what I call the long form, where you have to fill out every page, or the short form if it's below the threshold for estate tax and what is required to file the long 706. And so if it's a long form, we're going to want actual appraisals. So we will send out an appraiser to give us the date of death value for real estate. If they're stocks, we will send out the QSIP numbers to a company that we have that will tell us what the value was on the date of death. If there are other assets that need to be valued, we'll do that. Bank accounts will want the statement from the date of death. So we'll get all of those date of death values, put them into a spreadsheet for the tax return, and then we'll wait for 6 months from the date of death, because you're also entitled to use what's called an alternative date, which is 6 months after the date of death.
That could change the value of things.
That's why you get to wait. And if the stock market went way down or something else happened, you're able to use the lower value if you need to.
What happens if it goes up?
You can use the first value.
You have that option. Good to know. Where does the EIN come in to play?
So a tax identification number is, let's start with trust or probate. You give me the choice. It's used for both.
Say trust.
Okay. So what happens is most trusts we're dealing with are called grantor trusts, which means they use the trust makers, the grantor's social security number. When that person dies, the trust creates an administrative trust, and you get a tax ID number for that. And oftentimes now you're putting assets into that new account that you might open with the bank with the new tax ID number. And if you have to sell real estate, the real estate proceeds will go into that account. If you're selling stock, the stock might go into that account. Or if you're collecting life insurance, the life insurance proceeds will go into that account. And so we get the tax ID number when somebody dies for the trust so that we can start opening up, so the trustee can open up accounts and start putting assets into it.
Good to know. Then what happens?
All right, so now we've gathered up all of the assets. We filed the estate tax return. If there was estate tax due, we pay that. We get a letter back from the Division of Revenue, what I call the Division of Taxation, and they tell us that either there was no tax due, so a certificate of no tax due, or that we paid them what was the appropriate amount. And they'll also file what's called a T-77, which is a release of that inheritance tax lien. Then we've got clearance now to start distributing out the assets in accordance with the terms of the trust.
On the other side of the ledger, while you're looking at and appraising things that might have increasing value or decreasing value, when the person dies, they still have these bills that have been in place. Who's paying for them, and do you deduct that on your spreadsheet from the value? We had 6 months of utility bills, 6 months of their tax, whatever it is. Can't even imagine. But there are things that need to be paid ongoing, whether it's you settle it in a month or 6 months or 6 years. When does that come into? How does that come into play? Do you keep paying the bills for somebody?
Yeah. So if it was an estate, you opened up an estate account to pay bills. If it was a trust, there's the administrative trust account that's going to pay the bills. And some bills are deductible from the estate tax if you have a taxable estate. If you don't, then we don't even worry about the expenses because it's not going to be taxable anyway. But yes, they have to keep up with bills, and you have to pay out other things that might be expenses. The funeral bill, obviously, the cost of the last, medical bills, the credit card bills, perhaps.
Are you paying that out, or is the executor suddenly getting, if I'm the one who passed away, my checkbook, and she has or he has the ability to sign off, is he paying out of my checkbook at that time, or does it all have to get transferred to you or a lawyer to do those things?
Usually it goes to, not the lawyer, to the executor or trustee who's opened up an account for the estate.
A new account for the estate. Got it. Are you required to pay all of your credit card debt?
So you can't pay it because you died.
I can't.
Right.
My executor could.
Right. So if you have an estate, then they can file a claim against the estate, and then the estate can pay it, or if there's not enough money, negotiate the bills down. If there's no estate, so somebody dies and they had no money, you as the executor or the administrator or the next of kin or the spouse don't have to pay any of the person decedent's bills because there's no money to pay them.
On the one hand, that's sad. The other side of it, it's understandable. How long does it really take after you've figured that 6 month might be that 6 month window for you to distribute assets? Does that take a long time? And are you the person who notifies everybody else who might be on that list to get something at some point?
Usually that's how we do it, but we work with the trustee or the executor as to how they want us to do it. We don't have to wait necessarily till the end to distribute something. So for example, if there are specific bequests, $20,000 to St. Jude's, $10,000 to the Wounded Warriors, $5,000 to Joey from our first example before. Those specific bequests can be paid out. As long as we know there's going to be enough money to pay all the expenses and cover everything, we can pay that out. If we know there's more than enough money to cover everything, we can pay out what I call a partial distribution or an initial distribution to the beneficiary, so they don't have to wait till the very end to get something. If there's a question as to whether or not there's going to be enough, then we'll generally wait.
Most people might have jewelry and wall hangings and a piano if they had it. Those aren't things that are necessarily going to be liquidated, but they might be. that goes into a will? Wasn't there something called a codicil? Well, a will. And can those things, those items, tangible items, can they be immediately distributed? So and so, I want you to have my grandmother's pearls or whatever.
Yeah, generally you distribute the personal property out as soon as you want to. You're exactly right. They're not going to be liquidated usually. I want my grandmother's wedding engagement ring or the car or something. Those things are usually distributed out.
Going back to the planning issue, and we were talking a little bit about things that become international. You've always spoken about a power of attorney. Do you need to have a separate power of attorney on the other side of the pond, so to speak, too?
That becomes difficult, and you may have to talk to a consulate if you're not in the foreign country or whatever, as to what they'll accept. Because some countries will accept some of our documents with an apostille stamp on it.
A what stamp?
It's a stamp from the Secretary of State's office, that it can be used internationally sometimes. Other countries might not accept any of our documents, so you need to speak to an attorney there.
And so if someone has made some provisions, plans ahead of time, and you were aware of it, it would be you who contacts someone who's on the other side of the pond, so to speak, or how does that work?
We have done that, and sometimes the client is already taking care of it directly with the lawyer that they might have engaged early on in the plan.
Does that end up making the settlement of the estate take much longer?
It depends on the country and the situation. Generally,
These
no.
days?
Yeah, usually not, because usually it's separate. But we were talking about those difficult children before, and so how can that be impacted in the plan you put together for your estate? So I had another case one time, and the planning in that was very important to the settlement. So here was the situation. Mother and father got older and became a little bit, needy, and the son left his job, moved in to take care of them. And the sister, who didn't live there, was difficult. And the mom died. Now the son is taking care of the dad. And the sister would come and visit, and when she'd leave, the dad would say to the son, "What did she steal this time?" Because she would always take something. And so the dad came to me for his plan. And he had a very, very nice house that was worth quite a bit of money. We'll make up numbers, let's say $2 million. He also had a big retirement account that was worth $1 million. And so he created a trust, and he put the house into the trust, and he made the trust the beneficiary of the retirement plan. And he left the house to the son and the retirement plan to the daughter. And he also put in language that we often do: if anybody contests this trust, they don't get anything, they're out. So he died, and the trust, became the administrative trust, and we notified the daughter that he died, and she asked for a copy of the trust, so we sent it to her, and she said, "I'm hiring a lawyer, I'm going to contest this." I said, "Have your lawyer contact me." So we sent the trust to the lawyer, and I pointed out the section where she wouldn't get anything if she contested it, and he convinced her that it was better to get $1 million than nothing. And so here's how that planning worked in that case. There were two things that were very important. Obviously, if you contest it, you're out. But it was also important that he didn't name the daughter directly as the beneficiary of the retirement account, but rather the trust. Because if he named the daughter the beneficiary, the trust has no effect. It goes directly to her. So then there would have been no reason for her to not contest the trust if she wanted to, because she wasn't getting anything else in the trust.
In that case, or in a case where someone isn't named in the trust, could they call an attorney and say, "I want a copy of the trust"? And is the attorney, are you, obliged to share a trust with someone who isn't named in it?
Generally speaking, no. And that's one of the reasons people like to use trusts rather than wills, because they're private. A will has to go to court, which is public, and anyone can look at the will. A trust is private. So you don't have a right to ask me what's in the trust. I provide it to you if you're provided for in the trust. If you want to find out and you don't like what the situation is, if you're an heir at law, meaning under the rules of intestacy, if there was no trust you would inherit, perhaps then you could sue and get, through discovery, a copy of it. But you can't, if you call me up and just say, I want to see a copy of it, and you're not in it, I'm not giving it to you.
You said a will is public document.
When it's probated.
When it's probated, someone's not listed in it. Can they still contest it? I know that he would have wanted me to have something. I want to contest this. Can they, not being named in the will, can someone outside of that protest and contest a will?
Who's the person?
Person's not a family member, just an outsider. I was really close to Mary. I know she would have wanted, she was getting a little, whatever they say, she was getting a little senile, or I know she would have wanted me to. Do they have any claims or any right?
Let's say that person wants to contest the will, as you say. That means they want to claim that the person didn't have the capacity to execute the will, so that the will would get knocked out. And if the will got knocked out and there were no other wills in place that might step up or that type of thing, then we're dealing with the rules of intestacy. And the rules of intestacy, if you're not an heir, you're still not getting anything. So the way
Good for someone to know.
The way that person might want to contest it is not to say that the will's invalid, because it wouldn't do them any good, perhaps. But if they thought they were promised something, or they did work for them, took care of them and thought they were going to get something, and they could make a claim against the estate. And that's a bit different, and so they'd have to prove their case, but that might be a way for them to get paid.
Access to something.
Yep.
In the brief amount of time that we have, I came across a term, maybe you can explain it. What is the Real Estate Settlement Procedures Act, something called RESPA, and it says it's a federal law that dictates how lenders operate and requires borrowers be provided with appropriate disclosures about the costs and the nature of the settlement process.
Yeah, but that doesn't have anything to do with estate settlement. That sounds more like real estate or something of that nature.
So if real estate is part of the estate, what happens? Doesn't apply?
Not estate settlement.
It's not about estate planning.
No.
Has nothing to do with estate planning.
No. Estate settlement is a state-by-state thing. It's not governed by federal law. So that has doesn't have anything to do with trusts or probate or any of that nature.
Thanks for that clarification, because someone actually asked me that, and I had no idea. So when I looked at it, I understood that it said estate, but it didn't say an estate plan.
I think I'd have to look at it. I think it's real estate.
Just real estate.
Yeah.
Good to know. That's why we ask these questions of Attorney David Bizarre. We hope that this has been helpful to you. We hope you will continue to stay tuned to the Law Matters, as we say, matters to you. Thank you for tuning in.